the evidence by witness and allocated the evidence by witness by page. So in fact, what we did was we totaled up the number of pages of evidence over the 100 days or so. We were getting them actually every week, and did it that way. Now, he gave a number of specific directions to the assessment officer and referred him to the chart, but did not or would not specifically allocate percentages, if you will. So that will cause some problem for the assessment officer, although the issues themselves, while they're not watertight, are fairly discernible. Now, I think that if you do urge a resolution such as that upon the judge, it would be of assistance to the assessment officer, particularly in those cases where you're not going to have a transcript. I think it has to be done, to have the trier, at least in a rough way, indicate what percentage or proportion of the trial he thinks were occupied by the issues upon which the defendant succeeded.
Terry, do you think we'll come to a system where you will plead the rule that you're relying on and ask for distributive costs in your prayer for relief, or at least get to a system where you write the other side and warn them that you're going to go after this?
I think you raise the issue no later than the pretrial. In fact, coming back to what his lordship said, I have a case in the Stratford list being pre-tried tomorrow morning in Toronto, and that issue will be raised and discussed. And I want the other side to be alert to the fact that if, as a defendant, if I'm faced with 3 or 4 heads or causes of action, and I only lose on one, so I think I will, then I want costs on the other issue, and because it's going to take me an extra week to try those issues. And I think a pretrial judge would appreciate hearing and dealing with that issue at the pretrial, because it could very much shorten the trial.
Yes.
So I'd give it in my own way. You're telling your story your way here. And I would, as best you can, go through the ritual in the first 3 paragraphs. I admit, I deny, I don't know, and then start from scratch.
Can I ask you a question, Justice Austin, and you don't have to answer this if you don't want to, but you've only been on the bench for a year or so, so you still remember what it's like on the other side of that elevated perch.
Vividly.
Is there anything that you see from a new perspective now? Have you picked up 1 or 2 things that were misconceptions when you're an advocate, now that you see it from the judge's point of view?
Well, the best witness in that regard is my wife. She says I've only changed in one respect. I used to go home at night and rant and rave and froth them out about those idiot judges. I've only changed one word.
Yes?
To waive it? There may be, but I can't think of one offhand. It says shall not, and I've had counsel say, well, we'll consent to you trying it, and I've said, no, I won't do it. I feel that would might appear to impair my objectivity on other cases if other counsel felt or heard that I had tried a case that I'd pre-tried. They might not hear that counsel had consented to it. So it isn't worth hurting the system to do that.
I have a question for Mr. Justice Austin. In a short trial, it has sometimes been the practice of counsel to hand up a document entitled Theory of the Plaintiff or Defendant's Case, which will include a sort of an outline of what the case is, the legal arguments, and a brief of authorities, so that hopefully the judge will follow the gist of the cross-examinations or examinations during the trial, and also have a chance to read the authorities during the course of the trial, or at least the legal points. Is that the kind of thing that you would find helpful when you're talking about written advocacy?
Very much so. Particularly the law, the authorities, and so on, whether you actually include them or just reference them. To this day, trial by ambush still exists in the minds of some lawyers, and frequently you won't have a clue what the theory of the defense is until counsel for the defense stands up and tells you what it is. In fact, sometimes when he's finished, I still don't know.
And hands you an unreported decision.
That's right, but it's the earlier you get this stuff, the better, and the more you get, the better. But they say trial by ambush dies only very slowly.
I guess the point I was getting to as well was, although you can't at that point address argument in the sense the evidence hasn't been heard, you do find it acceptable to receive from counsel the theory of their case and supporting argument.
Absolutely, and the earlier the better.
The late Walter Williston used to say it was amazing when you did that, how often you found all your own phrases in the reasons for judgment. That's good evidence.
That's right. You're writing the reasons. That's right.
Do you like excerpts of cases and highlighted cases, or are you a traditionalist with the full thing in there?
No, the less the better. Less is more.
All right, we're just coming to a conclusion. Is there one last question? Patrick?
I have a question, Mr. Solmon. In those rules of litigation, you talk about the time that doesn't discover its role in I haven't really had a case where I wouldn't want to see the other side's eyes and cross-examine and find out exactly what they're made of, if it's really going to be something that's going to go to trial.
Well, this was a question I wanted to ask you, Patrick, at the last panel, because I know you are at least one living incarnation of someone who's dared to go to trial without discovery. Perhaps you could share that experience with the group.
Well, can I took that over to Alan Heintzman here, because recently he said, you know, I fought in lots of cases and done so myself. He said, gone to trial and not discovery. At least I'm prepared to go to trial without discovery on the theory that discovery can take in more than time. And I've done it once, and I think on the basis of one experience, I can have enough of all your information, witness statements, and know the story.
All right, for the courageous among you, there's a parting word. I'd like to thank the panel for excellent presentations and an interesting discussion, and you for your kind attention. Thank you.